It was $8,000 in 7 days. Now, I'd say that hospital's got a billing staff. I don't know if they got any doctors or nurses in there, but by golly, they sure got some billing staff. Next morning, what's wrong with my little girl? We don't know. Let me see if I understand this. You took 35 x-rays at $44 each. You probably have seen every bone in that kid's body from every angle that you can possibly imagine, and you don't know what's wrong. Well, no, Mr. Gordon, we're just doing the best we can, and, you know, medical science doesn't know everything. I didn't ask you to know everything. I just wanted you to know what made the lump. And so this goes on for a couple more rounds here. CAT scan. What's a CAT scan? Well, that's the latest scientific medical marvel that's come off of the technological drawing boards. We put your little girl through here, and we took x-rays and pictures of her horizontally and longitudinally and cross-sections, and then we crossed the cross-sections, and, you know, they gave me this long spiel, and, you know, I only know 2% of the English language, and I don't know any medical language. Hold it, sweetheart. What does that mean? That means you owe us another $1,645. Oh, $1,645. But for $1,645, what's wrong with her? We don't know. You don't know what's wrong with her. Well, now you did some tests. What did those tests tell you? Well, they're inconclusive at this time. How much do we owe you? Well, I don't know. Well, how much does it cost to keep her in here? $500 a day. $500 a day. Okay, well, let me tell you where we're at so that we don't have any misunderstanding. I can't afford to pay you $500 a day for every day she stays in here. Therefore, I'm going to take her home. No, Mr. Gordon, she's too sick. Are you telling me I can't take her home? Yeah, that's right, you can't take her home. Okay. Well, let me tell you then so there's no misunderstanding. I'm not going to pay you. I'm going to take her home and let her die there. I cannot afford to let her die here. But, Mr. Gordon, this is the hospital. This is where she has to be because she's sick. Why in the hell does she have to be in the hospital because she's sick? Why can't she be sick at home? Why can't she be sick in the car? Why can't she be sick in a neighbor's house? I want to make her well. Tell me where to go make her well. Well, we don't know where that place is. Oh, neither do I. But I can take her to where neither one of us know where to make her well, and it won't cost us $500 a day. But, Mr. Gordon, the law. Oh, now we're getting down to the nitty-gritty. Let me show you the law. Turn to Idaho Code 18-1501. Now, I've included that in this lesson, and let's just read along with me. Any person who, under circumstances or conditions likely to produce great bodily harm or death, willfully causes or permits any child to suffer. Now, there's any child. Here's my little girl. She's crying. She's suffering. Or inflicts thereon unjustifiable physical pain or mental suffering, or having the care or custody of any child, willfully causes or permits. Now, there's the willfully permits. It's already there. I didn't cause the lump. I didn't cause the swelling. I didn't cause the pain. But here I am willfully then permitting it to go on. Permits the person or health of such child to be injured, or willfully causes or permits such child to be placed in such a situation that its person or health is in danger, is punishable by imprisonment in the county jail not exceeding 1 year, or in the state prison for not less than 1 year, no more than 10 years. Well, I'm not going to sit here and give you a reading lesson on that, but read it and check it out. What does that tell you? It tells you your kid is sick, your kid is hurt, something's wrong. You have to do something, don't you? You have to do some constructive thing. If you fail and the child died or some mischief ensued, well, you could go to jail for 10 years here. See how that goes? Now, here I am in the hospital. See? I don't have to sit there and tell that lady in the hospital that the kid is sick, and, gee, there's a law called Idaho Code 18-1501, and, gosh, I guess maybe, I'm here because of the law. I don't have to tell her I'm there because of the law. All I have to do now is just sit back and relax, which is exactly what I'm doing. Some guy sued me the other day for $2,000. They wanted $8 in the early days. Now it's bargain day at our local hospital, and now it's only $2,000. Good luck. Let's take a look at Idaho Code 161616. That's easy to remember. It's Idaho Code Chapter 16, which is the statutes in this state on child abuse. Okay, and it's Code 1616 or Statute 1616. Here's authorization of emergency medical treatment. Now, remember the little kid's in the hospital. I'll take her home and let her die there. Those were my words. At any time, whether or not a child is under the authority of the court. So, whether the child's under the authority of the court or anybody else, the court may authorize medical or surgical care for a child when a parent or legal guardian or custodian is not immediately available. So if I wasn't around, the court could order this, and cannot be found after reasonable effort, so they could look around the corner of the hall, and if I'm not standing there, they can move without me. In the circumstances of the case, or a physician informs the court orally or in writing that in his professional opinion, the life of the child, in other words, they can call a judge on a telephone. Once they've got oral authorization from a court, they can move, but watch. They don't even need that. I'll show you that in a minute. The life of the child would be greatly endangered without certain treatment, and the parent, guardian, or other custodian refuses or fails to consent. So, I refuse to consent. Give me the kid. I'll take him home, let him die there. No, you cannot take that child out of the hospital. See the admission of fact? In other words, I'm there getting facts, figures, and evidence. When I go into court, and the judge, you know, the state's going to, or not the state, but this hospital's going to move for summary judgment, I'm going to plead the facts. I'm going to say, Your Honor, Idaho Code 18-1501, Idaho Code 16-1616, Idaho Code blah, 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 and I'm going to go on here and read this in a minute. Fact 1, I took the child there because the law required it. Fact 2, I signed no contracts. Fact 3, I told that hospital plainly and their representatives I'm not going to pay you. Fact 4, I told that hospital I'll take the child home and she can die there. The hospital, Fact 5, refused to allow me to take that child. Where am I? All I'm doing is obeying the law, and now they want to charge me money for obeying the law. I was down in Winnemucca, Nevada not long ago, and someone down there in Winnemucca, Nevada was just really upset and uptight that I wouldn't pay this bill. I didn't want to take my kid to the hospital. I'd rather taken my kid to the nature path, but they locked him up in the penitentiary. I'd have rather taken my child somewhere else or done nothing for her for 2 or 3 days. But you see, the law required me to do that. And so I did it. Well, now that the law required me to do it, don't sit there and tell me I'm going to pay you. That's as insane as going into a store or having somebody come up to you. Here's a little better example, I think, having somebody come up to you and say, here's a gun, I'm going to shoot you if you don't sign that contract and agree to pay me $5,000. Well, certainly I'll sign the contract. Does that make it a valid contract? Check Miranda. If you don't think my theory of law is correct, why don't you check Miranda, page 458, the Testatrix formula. Let me go on here. Now under B, this is, what is this? Idaho Code 16-16-16-B. If time allows, in a situation under subsection A2 of this section, the court shall cause every effort to be made to grant the parents or legal guardian or custodian an immediate informal hearing. So if you want to, and if there's time, you can run in and you can complain to the judge. But this hearing shall not be allowed to further jeopardize the child's life. Now we're only talking about court so far. In making its order under subsection A of this section, the court shall take into consideration any treatment being given the child by prayer, through spiritual means alone, if the child or his parent, guardian, or legal custodian are adherents of a bona fide religious denomination. What if you're not a bona fide religious denomination? Here's your government telling you, well, if you belong to this government corporation, if you belong to this government licensed church, if you belong to the state religion that we're going to authorize and call that bona fide, then we'll go along with that. But if you belong, or you have, or you possess religious beliefs that are something other than state approved, state corporate chartered, state licensed preachers, well then we won't allow it. I contend that we have a state religion here in the United States. That's another subject. I'll cover that later. That relies exclusively on this form of treatment in lieu of medical treatment. After entering any authorization under subsection A of this section, the court shall reduce the circumstances, finding the authorization to writing and enter it in the records, and the court shall cause a copy of the authorization to be given to the physician or hospital or both that was involved. Oral authorization by the court is sufficient for care or treatment to be given by, notice that, oral authorization. Telephone call by the doctor. That's all it requires. Some nurse, some health physician, some health person. Hey, we got a kid in here with a lump on her back, and her old man's a religious wacko, and he won't let us operate, and we need to operate. And it's going to jeopardize the child's life in the next 16 minutes. So think fast, Judge, because we got to move. Well, this hospital is a quasi-government agency, for crying out loud. It's licensed by the state, incorporated by the state, and here's all of its staff licensed by the state. All the nurses are licensed, all the doctors are licensed. It's a quasi-governmental monopoly, is all medicine is in this country. We have socialized medicine in this country. We just call it by a different name, that's all. Okay, I'm going to go on and skip down here to Idaho Code 161619. Listen to this one. Reporting of cases of physical injury to children caused by abuse of parents. Well, we notice that the lack of attendance, or the lack of the failure to perform under Idaho Code 18-1501 is cause for abuse or neglect. You could go to jail for that. That's the criminal section. Now look over here. Reporting cases of physical injury to children caused by abuse of parents or neglect, in other words. Any physician, resident on a hospital staff, intern, nurse, coroner, school teacher, daycare personnel, social worker, or other informer of the Gestapo, having reasonable cause to believe, that is, any pretended belief, that a child under the age of 18 years has been abused, or who observes the child being subjected to conditions or circumstances which would reasonably result in abuse, shall report or cause to be reported within 24 hours such conditions or circumstances to the proper law enforcement agency. I'm talking about the Gestapo now. The department shall be informed by law enforcement of any report made directly to it when the attendance of a physician, resident, intern, nurse, daycare worker, social worker, or other informer is pursuant to the performance of services as a member of the staff of a hospital or similar institution, and shall notify the person in charge of the institution or his designated delegate who shall make the necessary reports. Then there's immunity, and then there's court records, and so on, support of the child. I'm not going to go into this all in detail here. I'll let you read it for yourself. You can check out your own statutes in your own state. Theoretically now, I would contend that because of this lesson, you're probably able to read legalese. That's right. We charge you money for what little you've learned here today. That's all there is to reading. You just read it, and it means what it says, and it says what it means. If it doesn't tell you to do something, you don't have to do it. And if it tells you to do something, then you do have to do it. If you have legal threats like you have here in this medical law here, as we have in the state of Idaho, and you probably have some there in your state, if you want to be subject to it, just sign all the contracts and all the forms and don't get real concerned about it, and just shut up and pay the bill. And if they sue you, then you'll just pay the attorney's bills and fees on top of it. I'm not going to pay any attorney's fees or bills. I'm not going to pay the hospital. I don't owe the hospital any money. I didn't contract with the hospital. I took my kid there because I had to. I took my kid there for the services that my government commanded me. They told me, we're going to shoot your kid full of snake venom and monkey pus whether you like it or not, mister. Now get that through your head, unless you belong to an authorized state, authorized religion. Now, do you belong to the state religion, or have you got some weird offshoot religion of your own? Well, I'm one of these guys. I've got my own weird offshoot religion of my own, and I'm not licensed by the state, and I told you I was a prophet. None of my prophecies came to pass, so we know what I'm not. We just don't know what I am. Now you're beginning to see how the law works. You're beginning to see how you can use the law to your own benefit. You know, you got socialized medicine in England. Take your kid to the hospital, they pay all the bills. Well, in this country, we have foundations, and this lady, this real barracuda, She said, oh, just sign this, Mr. Gordon, and sign that, and you can qualify for county aid. If I don't pay the bill, county will. If I don't pay the bill, there's a lot of foundations and other do-gooder organizations that'll pay the bill. Yeah, that's right. You're going to pay the bill through your taxes. But then I didn't ever want to pay the bill, and I don't sign contracts. And people put some piece of paper out in front of me and say this is just a standard, ordinary, everyday garden variety, run-of-the-mill slave-type document that all serfs, slaves, members, and subjects sign, and don't read because they're illiterate and incompetent and can't read and don't understand because it's got legalese in it. When they present that to me, I always say, gee, I'm glad you gave me this document. Here on paragraph 1, I propose then that we change the first sentence to read thus and so, and that in this second paragraph we delete sentence 1, sentence 6, and sentence 9, and that we substitute this statement or this. You do that in a contract. I dare you to. Want to have some fun? Go out in the hospital or the next time, I don't care where it is or what you're doing, somebody presents this contract. Go get a driver's license. Go down and sign up to register your car. Take a look at the terms and conditions and say, I propose that we change the agreement in this way. And watch that conversation turn to dust in a hurry. You're expected to enter into contracts like the lady I told you about. Her husband is sick or whatever her problem was. She goes in, oh yes, I'll sign here, 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 here. And she'd signed about 5 contracts, worrying about her husband bleeding to death or whatever the problem was. And then about a year later, they come into court and say, well, she voluntarily signed all the contracts. And so now she can just go right ahead and pay the whole $2,000 cash right now, today. Oh, well, what about the economy? And what about unemployment? And what about the fact that she doesn't have the money? And what about her good faith? And what about her honesty and integrity? Some of you are going to sit there and say, look, Gordon, you don't have any honesty and integrity. You're not even going to pay them. I've got facts of law on my side. I'm going to argue the case to win. I'm not playing the game because I've got this honesty and integrity. I didn't want to go to the damn hospital. I didn't want their damn monkey pus and snake venom in my kids' veins. They wanted me to take her there, so I took her there. Now that you wanted me to do this and you compelled me to do it, now try and compel me to pay. See, I've got rights. And I'm going to invoke my rights. I am not going to pay that bill. I don't owe that bill. Now, if I want to enter into a contract with the hospital, I'll go over to them and I'll say, hey, let me ask you a question. I need an operation. I have cancer and I want you to cut this cancer out of me. Will you do that? Sure we will. How much are you going to charge me? $10,000. I don't want to pay you 10. I'll give you 5. Oh, you're going to give us 5? Yeah. Why is it that I need this? Well, you're going to have intensive care. Why? I don't want intensive care. I just want ordinary care. How much is the hospital room? Well, it's $500 a day in isolation and $200 a day in a ward. Okay, I'll take the ward. And I'll give you $150 a day in the ward and I won't give you a dime more. At some point in time, they're going to say, look, we don't want your business. Okay, I'll go arrange a contract with another hospital. When I go to a doctor and I say, Doc, I need to have my cancer cut out, can you do that? I don't sit there and say, oh, please, doctor, don't let me die. I'm going to sit there and say, Doc, what makes you think you're competent to cut that cancer out? How many of those have you cut out lately? How many of those have you done in your total lifetime? How many of your patients die? What's your percentage of success? How much do you charge? Do you charge the same person, the same operation, the same price to all persons, or do you have a contractual scale that kind of fluctuates up and down with ability to pay? I mean, I can negotiate a contract. I don't have to go to a hospital and just sign a lot of papers because somebody tells me to. And by doing that, I create legal facts. And those legal facts are called fact pleading in the motion hearing. Now, I'm going to go through motion hearings, and I'm going to show you how to write a motion, how to plead a motion, how to argue a motion. I'll show you all about that. I'll show you the absolute necessity of being able to write and file motions and write and file pleadings. And that'll come in a couple of lessons. But up to this lesson, you need to know how to read. And so all we're doing here is talking about a reading lesson. Now, take these statutes and go through these statutes and underline the exceptions and underline the language and talk about it with your friends. And then take any statute, I don't care what it is, and anytime you're charged with a violation of law, always look for the exceptions and the loopholes in the law. Practice before you get into the courtroom. Before you get charged with something, lay it out. I was aware of the child abuse statutes long before I ever went to the hospital. I knew exactly how to bait them in. I knew exactly what I needed to do to cause the woman to say, you can't take the kid out of here. Oh, okay. Let's not get angry. I'm not going to fight with you. I just want you to know I'm not going to pay you. Now, with that bit of information on the record, that's a fact of the case. I'm innocent. I don't owe the bill. I don't owe the money. I'm not going to pay it. But the other poor lady, she'd gone in there and she just wanted to be as honest as she could be. And she signed the papers and she admitted she owed the money. And the only fact before the court is, do you owe the money? Let's let the jury decide whether or not I owe the $2,000. And then when the jury comes in with the guilty verdict and says, yes, you owe the money, as a matter of law, let's argue that case to the U.S. Supreme Court. And let's see whether or not my rights are being violated. Well, greetings again. Here we are with another lesson. And today I'm going to take up the subject matter that's on your list on your lesson plan number 18, and it's called The Common Law and Equity versus Chancery. So on this tape I'm going to cover the rule of 222, as we call it here at the school, arguing the Constitution in an equity court, what you should and shouldn't be doing about that, where it says axioms of equity, actually those are called maxims of equity. The traffic and magistrate court, Roman mercantile equity, chancery courts, equity and civil law, the common law, and it's entitled or captioned Common Law and Equity versus Chancery. And as you can see here in front of me, I've pulled out a plethora of books here with which to go through this doctrine of what kind of courts are we faced with here in the United States, and how do we secure our common law or our constitutional rights in those courts. Now, as we see it here in Boise, Idaho, there's only one court of original jurisdiction to protect our constitutional rights, and that's the Supreme Court of the United States. And to point that out to you from our vantage point here in Boise, Idaho, because of H.J.R. 192, which was passed in 1933, we have two things to consider pursuant to the common law, and that is the form and the substance of the law. All we have left now is the form, because the substance, which was our money, has been taken away from us. The common law in the United States of America does not exist. There is no substance for the common law, and for that reason, we don't have a common law. Fortunately, we do have a Supreme Court, and that Supreme Court is the last bastion of mankind's rights on this planet, and it resides in Washington, D.C. Now, that's a scary sort of a story. The bright part of it is that there are thousands of honest and bright judges, and there are thousands of bright attorneys, and there are millions of bright, sincere, and dedicated patriots nationwide. The problem that we're facing is that the patriots cannot get into the courts to talk to the right judges through the right attorneys, because the attorneys have their own selfish interests through their monopoly bar associations, and therefore those that are honest keep their mouths shut. And the judges then cannot hear, nor will they rule pursuant to Marbury versus Madison. So therefore the duty devolves then upon the patriots and the citizens to make Republican government work. Republican government works nicely in the courtrooms, and we've demonstrated that over and over and over again in the courts of Idaho. We, who are the free men in Idaho, have not had too big a problem going into the courts and espousing our doctrines and our rights. We have some problem in being heard by the lower court judges, because the lower court judges do not want to step out. They do not want to act because they want to protect their paychecks. All right, now with that much in mind, then what we need to keep in front of us then is the overall goal of trying to get our educational information before judges, so that those judges will then begin to act pursuant to Marbury versus Madison and Miranda, page 491, and that they will protect our rights at the lower level. Because at this point in time, what is occurring is we're compelled then to go into the appellate process over and over and over and over again. Now, we've been doing this here for 5 years in Idaho, and our chancery courts are beginning to recognize that there are rights, and that those rights are inviolate. That is, they're inalienable rights, and the judges are afraid now to walk on our rights. In the early days, they used to trample us underfoot with impunity because they didn't think we could do anything about it. Now that we've begun to initiate lawsuits, and now that the policemen in Boise, Idaho know that when you steal a free man's car, he'll drag you into court and compel you through the judicial process, they don't do it anymore. Within a couple of weeks of the filming of this tape, we'll be suing 2 judges, which is a matter of practical fact we generally try to discourage, because to sue judges, I think, sends the wrong message. But in this case, we have a couple of judges that will not listen to reason, that absolutely walk on us, trample on us, and are opposed to us in every way, shape, form, or manner, and therefore it's necessary and imperative that we take these 2 judges to law and begin to claim our rights and redress of grievance for those wrongs. So with that in mind, then, I want to read to you, starting here with this lesson plan, the common law. And there is a common law definition, and I'm just going to take the common law definition right out of Black's. Boy, have I got books in front of me today. But I want to get us started, and let's take a look then at what Black, who's probably a liberal commentator on this subject matter, I mean about as liberal as you can get, and take a look here at the common law and look at the definition of it is, because this is what we're appealing to. The common law is on page 250 of Black's Fifth, and it begins, as distinguished from law created by the enactment of legislatures. Boy, what a mouthful that is. See where it is? 1, here's my common law constitution. This is all the law I need. This is all the law that applies to George Gordon in the United States of America. Assuming that I can get rid of my marriage license, driver's license, business license, contractual agreements, welfare, food stamps, and all of the rest of the freebies and benefits that my government has enshackled and enslaved me with, there is a clear definition, a clear distinction then between the common law and the enactments of legislatures. When the legislature enacts statutes, it controls and creates, it controls and regulates, rather, its creation, which is its sovereign duty to do. The legislature is the sovereign over all of its creation, that is, corporations, trusts, foundations, etc. Going on, the common law comprises the body of those principles and rules of action relating to the government and the security of persons and property, and protection of persons and property, which derive their authority solely from the usages and customs of immemorial antiquity. I say it comes from a common law that began at Mount Sinai and was embodied in those land claims when those people crossed the Jordan River. Or from the judgments and decrees of the courts recognizing, affirming, and enforcing such usages and customs. And in this sense, particularly the ancient unwritten law of England, the common law, has all the statutory and case law background of England and the American colonies before the American Revolution. Then there's a citation in here, and it goes on. In California and in the state of Idaho, we have a similar statute. Here's the California statute that provides that the common law of England, so far as it is not repugnant to or inconsistent with the Constitution of the United States or the Constitution or laws of this state, is the rule of decision in all the courts of this state. And it's the same in Idaho, and it's probably the same in your state, with the exception of Louisiana, which is under the civil law. And boy, do I have something to tell you people down there in Louisiana about your civil law. Now I'm going to turn over here to, I think this is Bouvier's 1914 dictionary definition here of equity. And equity, I'm going to just read through some of the more salient points. There is an extremely long article here on the subject of equity. In fact, I'm looking at 3, 5, 6, 7, 8, gosh, there's 10. There's probably 10 or 15 pages on the subject of equity. But essentially, equity then is the King's statutes, or it is in fact the statutes of the legislature of the state of Idaho or Illinois or wherever you're from. Equity is that branch of remedial justice by and through which relief is afforded to suitors in the courts of equity. There's your second side of law. Equity is synonymous with this word called admiralty. And admiralty is the law of the sea, and it ends at the high water mark. We have been immersed here in the United States in admiralty jurisdiction. And as we go along, we'll show you how that admiralty jurisdiction through the Federal Reserve System has encroached upon our common law rights on the land. And so that now when we go into courts, we have administrative justice. We do not have common law justice. Now we think we've devised and we've come up with a plan whereby when we go into the courts, claiming our common law rights, we're able to assert and gain from those courts dismissals. Let me give you an illustration of a dismissal. As soon as I get through this equity, I want to tell you what just occurred here in Boise about a week ago pursuant to our common law rights in an equity court. But going on, I'm going to read some of these little barbs here to you. In cases where the jurisdiction of the courts of equity exists by commanding what is right and prohibiting what is wrong. So the court determines what is right and wrong, what is equitable. We'll cut the baby in two and give you the top half. But at law, I'm demanding the whole baby because it's mine and I can prove it. All right, and prohibiting what is wrong. In other words, its final process is varied so as to enable the courts to do that equitable justice between the parties which the case demands, either by commanding what is to be done or prohibiting what is threatened to be done. All right, now remember that equity also falls under the common law. We use an example like this here at the school. Let's suppose that your neighbor brings in 6 Indian cobras and he turns them loose in his backyard. And his motivation for doing this is to catch the gophers that are tearing up his lawn. You look over the fence and you are absolutely horrified by what you see, and you yell over to the neighbor, "Jones, what do you have out there?" And Jones yells back, "Mind your own business." You're threatened now with those snakes crawling under the fence and biting one of your kids, and so now you must get a restraining order. Here's equity. Equity does what must be done. We've got to get a restraining order. You call the police come over, they round up the snakes and they take them away from you. But wait a minute. You have a common law right to those snakes. That's your property. And those snakes were taken from your property. So now we have to do what is equitable, don't we? So equity does have a place in the common law. It always has. But there's always been a controversy as to whether equity or common law would prevail. And it appears that equity has won out. And our common law then is out of balance, because the common law only works when you demand it. You've got to be that belligerent claimant in person who goes into the court and demands his rights. Because here's the party demanding or claiming or desiring equity by simply calling the police and saying, "Hey, look at what that guy's doing over there." And now everybody says, "Wow, look at those snakes." But let's suppose now you, the owner of the snake, go into court and you say, "Wait a minute, there's been an error here. Those aren't cobras. Why, those are simply Indian mud snakes, and they're not poisonous at all." And in addition to that, what no one seemed to realize is that I put this special screen all around my property, and the snakes can't get through the fence into your property anyway. And for that reason, they're my property and I want them back. Well, unless your neighbor can show that those snakes are some kind of a threat, well, you've got to be given your snakes back, because property rights are one of the 3 basic inalienable rights, and that is life, liberty, and property. All right, so that's the way equity works. There's a simple, plain, simple explanation of it. So now what's happening to us is they're hauling us into these equity courts, traffic courts, infraction issues, and then charging us with various and sundry misdemeanors and crimes and prosecuting us by complaints and information. And what they're really doing is enforcing equity upon us, which are the King's statutes, which simply shamefully enrich the crown here, as I think we've seen in the past, where a very oppressive use was made of these informations for something more than a century, so as to continually harass the subject and shamefully enrich the crown, which is the purpose behind complaints and informations being brought against citizens, either in the traffic courts to protect the claims window of insurance companies, and to create taxation through the police powers in the traffic courts and in the lower courts of our judicial system. Let me go on here with a couple of more of these interesting little sidelights here to equity. This is particularly true of the principles which regulate the jurisdiction and practice of the courts of equity and of the principles of equity as they are now applied and administered in the courts of law, which at the present day have equitable jurisdiction conferred upon them by statutes and passed for that purpose. You see, the statutory jurisdictions that they're bringing you into are created jurisdictions by the legislature, and they do not apply to a free man. When the legislature creates statutes, it by and of necessity creates a jurisdiction to hear those statutes and laws. The statutes can only apply to a contractual party. Those statutes apply to you with building and zoning in this way. You buy a house. You have mortgaged your soul to the bank, which is the creation of the state. The state, because of the lobbying of the bank, creates statutes to regulate building and zoning to protect their property rights and interests. Therefore, you, through that contract, are bound to the property and to the zoning ordinances that are passed. You're stuck, friend. You better just do what you're told and shut up, because it's a proper jurisdiction. Now, that isn't to say that you can't win a litigation through procedure. That is, go into the courtroom, demand rights, demand counsel, demand rights sua sponte, demand a common law jury, assert your common law rights, and make the case cost the county or the city $1,500 or $2,000. Now, you're on the left side of the issue. That is, you're guilty, but it'll cost them $2,000 to collect their $100 or $200 fine. And that's what we recommend. That's what we do here regularly. And I recommend that everyone do that. But you need to recognize that if you took that case to the Supreme Court of the United States and were trying to establish some case law precedent, some common law jurisdiction, let me tell you, you just lose. It's the end of that argument. All right. The meaning of the word equity as used in its technical sense in English jurisprudence comes back to this. And that is, it is simply a term descriptive of a certain field of jurisdiction. There you go, friend. Equity is a jurisdiction, and it's in contradistinction to your Constitution. When you go into an equity court, there are no rights involved. Equity courts deal with statutes, and statutes can only be applied to parties who have licenses and some kind of contractual agreement. And other than that, there's no jurisdiction. Now, there are some fringe jurisdictions that we've talked about in the abstract, but as a general overall rule, there is no jurisdiction. If you're a free man, the statutes simply don't apply to you. Now, getting that into the courtroom is what we're going to be talking about as we go through lessons and lessons and lessons. But that you might know, and I know this is pretty heady, because when you talk to people and you say the reason that you're having a problem with your government is that you're not a citizen, you're a subject and a member, and therefore you don't have any rights. And of course you don't have any rights. You go into that traffic court, there are no rights involved, so you've got two jurisdictions here. It's a certain field of jurisdiction exercised in the English system by certain courts, and of which the extent and boundaries are not marked by lines founded upon principles so much as by the features of the original constitution of the English scheme of remedial law and of the accidents of its development. Well, let me say this. This moment in time, you need to pick out Bouvier's 1914 and 1870 model dictionaries and then take out Black's Fifth and cover the subject of equity and common law so that you have an understanding of these two basic kinds of law. And at the very top of all law, then, you've got common law and equity. And once you've got that down pat, now we can go on to what is the second of the rule of 222. And it's simply this. Once you've got the common law or equity laid out so that you know what it is, what subject matter you're talking about, it's divided into two more branches. And that's simply civil or criminal. Now, civil then is simply an action to regain redress of grievance for loss of property. An example of a civil case is, I'm driving down the road and I run into your car. Okay, that's a civil action. It's a loss to you. I ran into your car. There's nothing criminal about it. It could be criminal, though, if I were angry with you and I said, I'm going to get you, and I jump in my car and I peel out and I ram your car, and then I back up and I ram your car, and I back up and I ram your car again. Hey, now we've got some maliciousness involved in this. This could be attempted murder. Now we've got crime. So here's common law, civil and criminal. Well, over on the other side, under equity, you've got civil and criminal. But you see, under equity, civil and criminal can't apply to you if you're a free man. Because here's your shield. I'm demanding my rights at law. I've got to be prosecuted by the people of the state of Idaho. I've got to have a grand jury indictment. Listen to this grand jury issue in Idaho. Now, we've been working on this, and we can show you, and you can look for yourself under grand juries and informations in your own state and in your own state constitution. But listen to what we have here in Idaho. Prosecutions only by indictment or information. No person shall be held to answer for any felony or criminal offense of any grade unless on presentment of indictment of a grand jury or on information of a public prosecutor. That's Article 1, Section 8 of our state constitution. No matter what state you're in, watching this set of tapes, take a look at our state constitution, because in your state constitution you're probably going to find something similar to that. Whether you do or not, it's guaranteed you in the Fifth Amendment of the federal Constitution, wherein it says, and I think we've gone over this, but let's just run through it again here so that you can have a good understanding of it. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. Now, there are two key cases to keep in mind on this grand jury indictment pursuant to the common law. Friend, it's easier to win a felony than it is a traffic ticket. I'm just telling you, I've argued a lot of cases, and I'm on my second felony now. And I know that makes me sound like a bad guy, but believe it or not, you know what I'm charged with a felony? Stealing 2 traffic tickets from our traffic court. I'm telling you, they don't like me here in Idaho at all, and I just don't know why for the life of me. I want to point your attention here to a case called Ex parte Wilson, 114 U.S. 417. So you might write that down. That's Ex parte Wilson, 114 U.S. 417. You'll get the Wilson case, which is just a few pages, with this lesson. All right. What this does in Ex parte Wilson is shows you that this issue of grand juries and informations are absolutely imperative under the common law. So when you get into a jurisdiction in Idaho, for instance, where you're prosecuting by information, I quote Wilson, I quote Mackin. And I'm going to give you the second case, which is Mackin and another versus U.S., which is 117 U.S. 348. And to give you a citation or two, I'll just give you an idea. Here's a couple of fellas who were prosecuted by information and that the Supreme Court turned loose because they were not properly charged by a grand jury. You absolutely have to have a grand jury or the jurisdiction fails.